going to have maybe one or two little trivia questions right quick before Mr. Quinn gets started. Take your seats. Thank you. Before the presentation today, how many of you knew that Abe Fortas was from Memphis, Tennessee? Raise your hands. Before the presentation today, how many of you knew Abe Fortas was from Memphis, Tennessee? Wow, okay. I didn't. and you all knew that he was an associate justice for the Supreme Court? All right, okay. Well, can anybody tell me in the general area where Abe Fortas grew up, where he lived? All right, I see one hand in the back. Will you tell us? All right, that's correct. That's correct. And that's right over behind the FedEx Forum. All right. And we learned from, I believe, was it Judge Folks that told us where he went to college? And where was that? Rose College. All right. Well, our next speaker is going to be Mr. Art Quinn, who's going to talk to us about, he's a member of the Criminal Justice Act panel for the Western District of Tennessee, and he's going to talk to us about the birth of the Criminal Justice Act. Mr. Art Quinn.
I knew Abe Fortas was from Memphis simply because I think his brother owned Fortas Fine Furniture, which was down there on North Main, in case you ever ate at the little deli down there. Remember Abe's Deli? Used to be down on South Main. Doris assigned this very exciting topic, the birth of the Criminal Justice Act. And of course, that's why most of us are here. Most of us in this room are either federal defenders or CJA attorneys or involved in the federal system. Gideon, and we talked about Gideon, actually the 50th anniversary of Gideon was last year. This year's the 50th anniversary of the Criminal Justice Act. And on the way to work today, and to celebrate the 60s, I put my Booker T and MGs CD in, and you young people don't even know who Booker T and the MGs are, but it's good music, let's put it that way, from our heyday, right, judges? Gideon applies to the states. We're, at least most of us here, are involved with the feds. And it's Johnson versus Zerbst, which really set out the right to counsel in criminal cases for federal cases. And that was a 1938 case, or 36 or 38 case. So we really ought to be, instead of having a Gideon celebration, we ought to be having a Zerbst celebration. And it'd be more fun to say anyway, Zerbst. We'll have a Zerbst celebration. But Zerbst was written by Hugo Black, which, as Judge Breen said, was from Alabama. He was an Alabama trial lawyer that eventually made it to the United States Supreme Court. He wrote the opinion in Zerbst. And then a few years later, they did not, in Betts versus Brady, extend the Sixth Amendment to the states. Black had a strong dissent in that case, the Betts case. So with all due respect to Leslie Ballin and Abe Fortas, when it came time in the mid-60s, Black was looking for a case to reverse Betts, and Gideon happened to be it. And so I'd like to think they really threw Abe Fortas a little slow pitch, tee it up and go for it. But nevertheless, a very important case. But Zerbst gave the right to counsel in federal cases. But things still weren't going so well, even in federal cases. So in April of 1961, Attorney General Robert Kennedy, and sort of a hero of mine growing up, created a committee to identify some of the principal problems in the system of federal justice of accused persons of limited means and to offer suggestions for their solutions. Now look at the timing of this, just after the Kennedys came into power. And he appointed a law professor, Francis Allen, to chair that committee. what is really ironic, earlier this year there was a sort of a high-profile DUI. Kathleen Kennedy, the daughter of Robert Kennedy, I think she's a congressperson, got a DUI, went to trial, and then the next day Matt Lauer's interviewing her on the Today Show, and all she wanted to talk about, instead of pulling the Kennedy card to get an acquittal, talk about, oh, but this year is the 50th anniversary of the Criminal Justice Act, and I had the right or I had the ability to afford good, competent counsel, but my father helped pass laws that would let everybody have competent counsel. Of course, Matt Lauer was trying to, just gig her into saying, well, yeah, but I did play the Kennedy card in getting an acquittal. The Allen Report proposed legislation that became the template for the Cja Act. This report was submitted to Attorney General Kennedy 3 weeks before the Gideon decision. So the feds were moving this way all along. And the Gideon, I think, reinforced it. But even in Gideon, if you read the decision, 22 states were already on board with Gideon. Even though ZERPS was decided in 1938, federal courts had placed the entire burden of representation upon appointed attorneys who received no compensation from the court, had available no funds to pay the cost of the most essential defense services, and who generally did not even receive compensation for out-of-pocket expenses. And then even 6 years after the act, the rates, the CJA rates, were $5 out of court in 1970 and $10 in court in 1970. Not a whole lot different from what it is in the state of Tennessee today. $40 an hour is what the state of Tennessee today pays to defend people's liberty. Yet, one arm of our local government hires a lawyer at $510 an hour to litigate against another arm of the government. Happened just 2 years ago here in Shelby County. And I was a public defender for my first 3 years out of law school. And I can remember when I was hired by a firm, I left the public defender's office, and I told them, I said, I'd still like to do some criminal work and probably involve court-appointed work. And I was told, oh, that's fine, just do it late in the day or on weekends. And that's sometimes, I think even now, is the attitude of some of the firms, that court-appointed work is pro bono. It's not. It's the obligation of the government to provide competent counsel for people that can't afford a lawyer. Yet the rates are very low. Now, and it's tough to criticize the federal government. Even though the rates are relatively low, they're a heck of a lot better than the state. And the courts readily make available the services needed in order to adequately defend people. And along those lines, by the way, I ignored that directive about waiting until late in the day or weekends to work on my criminal cases. But I remember, and I'll mention their names, 2 CJA lawyers, Mike Stengel and Cliff Harville. I remember going over to their office a few years back and talking to their secretary when I was waiting on one of them, and their secretary made the point to tell me, you know, Art, I can't tell the difference when they're working on a court-appointed case or a private case. And to me, that is the standard that we all ought to have. And I think that's the standard of the CJA lawyers I know. It is, that they try their hardest regardless of the kind of case, whether it's private or court-appointed. The Allen Report found that there was a high rate of guilty pleas and the disparity in the plea rates of those with retained counsel and those with assigned counsel, and that was particularly telling. So now, all you CJA lawyers are all huffy, and you've changed the system, right? You've changed the world. Not quite. Since 1963, and I know that's tough to read. Let me read these stats to you. Since 1963, pretrial detention rates have doubled. The duration of pretrial detention has quintupled. I think that's 5 times. In 1963, 15% of all federal defendants went to trial. In 2010, 2.7% went to trial. Okay. Now, the reason for that is not the lawyers. The reason for that is there's just been a tremendous change in the nature of federal court and the criminal practice in federal court. Even though I'm sure the judges don't want to hear it, the way some of us lawyers affectionately refer to federal court now is state court west. It's the nature of the cases and the nature of the beast, and the building is just horrible in terms of getting prisoners in and out. I have a trial this week going on, and if you're interested, closing arguments are at 12:30 today in Judge Mays' court. But, you know, my client didn't have any clothes, so I've got to bring some clothes for him to wear in front of the jury, and I'm rolling into the building. And, of course, now you can only get into the building on Front Street. And, you know, so the jurors are lined up behind me as I'm carrying some clothes they're later going to see on my client. So, oh, well, they'll never guess he's really in jail. But I'm sure sooner or later they'll build a new building and everything will be fine. But even the Supreme Court in the last couple of years has recognized that criminal justice today is for the most part a system of pleas, not a system of trials. In the last 50 years, defendants in federal courts have become poor, disproportionately more black and Hispanic, and subject to a system that affords them fewer trials and imposes more frequent, lengthy pretrial detention. The United States now imprisons 1 in 100 of its adults, a rate surpassing every other country in the world. And I'm getting my stats from a Yale Law Journal article written by, I believe, the New York federal defender. It was a June 2013 article. And just as an aside, and Doris, I don't know whether y'all found it in your office, but it seems like the kind of defendants we're getting now, and even back in my day as a defender, a assistant county public defender in the late 70s, early 80s, the clients always sort of, you know, we weren't real lawyers, you know, looked down on us sort of. But it seems like more and more in federal court now, the clients don't want our help. You know, whether they're sovereign citizens or believe in the Uniform Commercial Code, they're not cooperative. And I know my good friend Gene Lorenzi here recently spent a week in trial, and his client never talked to him. And it's difficult, you know, well, obviously it's difficult when your client won't even discuss with you his version of the facts of the case, but just the attitude has changed. And you know, it's one thing where they don't look on us as a real lawyer, but it's another thing when there's really just no cooperation at all, and it just seems like there's more and more of that. All right, I gave a little talk at a federal bar seminar last year, and I just thought I'd throw these facts out, or stats out, and endorse, I mean, I know earlier, well, let me tell you what this is. These are stats from Western District of Tennessee filings by defendants in 2011 and 2012. In the 45%, Doris, what the clerk told me is that about 55% of the cases were handled by court-appointed attorneys, either federal defenders or CJA lawyers. And I know Judge McCall in his introductory remarks used a figure of 80%, and that may be nationwide, and I don't know if there's a distinction in districts or not, but that's the figure the clerk gave me. And I really just pointed that out because that then shows the number of cases annually available for you private lawyers that want to try to get into federal practice. And you figure we've got CJA lawyers in this Western District. We've got in the Memphis panel about 40, and I think there are another 15 or 20 in the Jackson panel. So we've got about 60 lawyers that are willing to serve, that do serve on the CJA panel. I know there are a number of other lawyers that are willing to take criminal cases. So I guess my point is, on a private basis, you know, that would only average out to about 3 private cases a year per lawyer. It's not a real lucrative or not a big volume area that you might want to think about going into anyway. The part of my topic is who are the CJA lawyers? And we get a list every week of who the CJA lawyers are, and I suppose you didn't want me to read off those names. So, but in looking at the list, virtually all the CJA, it goes back to a little bit about what I said when I was hired in private practice. In looking at the list, there are only 2 lawyers that were not either solo practitioners or small firm practitioners. Chris Sullivan is with the Thomas & Hendricks firm, or they merged with somebody recently. And then Andre Mathis is with the Glankler firm. But other than that, I think everybody is small firm or solo practitioner, which makes some sense, though, because I think maybe big firms do dissuade lawyers from taking court-appointed cases, although I know, I mean, Tom Gould has mentioned it to me, big firms have approached him about how to get their younger lawyers into court. A couple of years ago, I was elbow counsel for a big international firm. They were based in New York. They came down here on a state death penalty post-conviction, and they did a great job, but I think one of their main motives in doing it was to get their younger lawyers involved in the court. I mean, they did a great job. They were all very intelligent, and even had the transcript basically memorized. But that was that firm's way of trying to get their lawyers in court and involved more in casework. The big firms maybe are missing an opportunity to get their lawyers in court more. Getting a little more philosophical, who are the CJA lawyers? Well, I think CJA lawyers are people like Howard Weigerman and his defense team, who tried the only death penalty case in this district to conclusion and saved his client's life. Or Mike Stengel and his co-counsel, who represented a cop killer where the crime was on video, a hardened criminal, yet they worked hard enough to get the trust of the client so he would sign papers for life, thereby saving his life. I mean, that's part of it. Or Gene Lorenzi, stuck in a miserable trial where your client won't even talk to you for a week-long trial. But that's what it's about. And, the little show we had today is the hero, in my opinion, not David Bell, but the role he played, Fred Turner. The ACLU tried to get a lawyer to represent Gideon on the remand, and Gideon said, nah, I know there's other lawyer down the road, and it was crusty old Fred Turner, but who was a good local trial lawyer, who investigated the case, tried the case, and as they indicated, within an hour, the jury came back with an acquittal. So, Fred Turner, not Gideon, or not Abe Fortas, to me, would be the hero. He was the local attorney that took the court-appointed case. Who else are CJA lawyers? To me, now, a few years ago when I was president of the bar, I had to give a lot of talks, but I always pointed out, on most of my talks anyway, that a few years ago, the American Film Institute listed its top 100 heroes. The top hero was not Superman or Indiana Jones, but it was Atticus Finch, a small-town country lawyer willing to take a court-appointed case. And an excerpt from the book is when the neighbor lady is talking to Atticus' 2 children after he loses the trial, and he lost the trial. I simply want to tell you that there are some men in this world who were born to do our unpleasant jobs for us. Your father is one of them. We are the safest folks in the world, said Miss Maudie. We are so rarely called upon to be Christians, but when we are, we've got men like Atticus to go for us. Now, I know Atticus is a novel. He's a fictional character. But the CJA lawyers do that, and they really do. They fight for their clients, and It's something I am proud of. I've been on the panel since Gene Lorenzi talked me into applying for it since the early 90s. Now finally, I'm a Notre Dame graduate and a big football fan, and I just want to tell all of you defense lawyers to, the team slaps the sign, play like a champion today, so you guys need to get out there and defend like a champion today. Thank y'all.